Afternoon, and welcome everyone to our data protection webinar on subject access requests, or how to handle data protection subject access requests. This is one of those topics which has grown increasingly of importance because of the number of requests that we are seeing our clients and employers get generally. So I thought it would be a useful idea to sort of cover what the frequent topics or questions that we're getting asked in this area are, and how we deal with those more troublesome requests that sometimes we get. So yes, this session is going to last an hour. Okay, so I will ensure that as we're going through the session that I'm running on time. I certainly won't overrun, that's for sure. So I will go through the presentation that we've got here. As I said, if you've got any questions, then just pop them into the Q&A box that should be on your screen. I can't remember whether that's on the right or the left of your screen, but just have a look there. And if you want to ask any questions during the session, then I will do my best. I endeavour to answer them as we go through. If I don't know, don't fret, because if you ask the question, I'll have seen it, and I'll make sure that I follow up afterwards when I send the slide deck out. Subject access requests. So what have we got on subject access requests? Well, subject access requests, as I said, I mean, data protection is quite a big beast in any event. Obviously, since the advent of GDPR, we've all got our data protection policies, our privacy notices. Some of us are providing training to our managers and supervisors to make sure that they're treating their data, not their data, sorry, but the data that they are managing about the employees that they manage in an appropriate way. But subject access requests themselves, you see, they're nothing particularly new. They've been around since 1984. And what they require the data controller, which of course is in an employment environment, is the employer, to comply with any subject access request. Now, back in the day, subject access requests were fairly straightforward and fairly easy to manage, because it was literally you dig out the personnel file and you photocopy that and send it to them. But of course now it is much more complex, because the development of digital technology and the expansion of the information, that particularly the expansion of printed information and stored information that we have on employees, has grown beyond, well, it grows exponentially every single year, doesn't it, with the number of emails that people are sending, the number of text messages, and all of these other communications devices, including Teams as well. And so it's grown into this big beast. And so now when we get a subject access request, it really can become quite onerous. Now, that's not to say that the government doesn't recognise this. It has just undertaken a consultation into the data protection legislation. That consultation closed in the middle of November of last year. And what a few of those things that the government is looking at is it's looking at whether it should be reintroducing fees, sort of nominal fee structure, because again, remember, before GDPR, then the employer was able to ask the employee to make a £10 contribution, which admittedly is only a nominal fee, but it did begin to manage the number of subject access requests that an employer was receiving. It's also looking at a cost ceiling for employers. So where the cost of complying with that request is excessive, then perhaps that would then enable the employer to be able to reject it, or at least limit the scope of the subject access request. And it's also going to be having a look at what it defines as manifestly unfounded. Now, I'm going to turn to manifestly unfounded a little bit later and what that means. But essentially what we've got here is that, of course, again, we didn't have all of this information being generated previously. And this rather silly image is just to reflect the fact that, if we were creating paper documents every single time that we were sending a message, then this is the extent of the creation of information of people that we are generating. So we've got all of this unstructured data There'd be emails, text messages, other messages through other systems. And then, of course, that information often includes the information of more than one individual. Whereas, again, going back to the old HR file, personnel file, generally it was very easy because that information only related to that individual. Whereas now we've got a much bigger task to not only find a much larger volume of information, but also to then be looking at that information and making sure that we're not breaching the rights of any other individual that might be identified also in that other data. So it's become very, very tricky indeed. But what we're going to have a look at is we're going to have a look at some of the frequently asked questions that we get in this area. And so we're going to have a look at what the time limits are to respond, when you can extend the time limit, what information you've got to provide, when are requests excessive or manifestly unfounded, which is the phrase I just referred to. What do we do when there is information of others within that relevant data? When can you redact? When should you redact? And just for the avoidance of doubt, redacting is just where you black out the irrelevant information, so you make sure that the individual can't see it. And when can you refuse to comply? So that's really the approach that we're going to take to the next hour. Well, actually less than the next hour, of course. Now, of course, the objectives of the Data Protection Act 2018, which was implementing the General Data Protection Regulation, GDPR, it's got two main objectives. One is to protect data, essentially the security of data, and the other is to give users control of their data. And so who are the stakeholders? Now, we often hear these phrases and this terminology. I'll just make this a bit bigger so you can see it completely. So you hear about data controllers and data processors and data subjects. Well, obviously in an employment context, the data subject is the employee, or are your employees, and the employer is generally the data controller and also the data processor. Sometimes it isn't both, depending upon where the data is stored or where the data is going to be used. So you might have outsourced payroll, for example. But largely speaking, with the majority of the information that we're looking at in relation to subject access requests, the employer is the data controller and the data processor. So just for you to bear in mind those bits of terminology, not so much for the way I'm going to be referring to it during this session, because I will just simply be referring to the employer and the employees, because that's the easiest way of doing it. But in case you're reading other guidance, then that is just a quick reminder for you. And of course, I'm sure you will have all been on seminars a few years ago that was telling you about the importance of complying with GDPR because of the extraordinarily huge fines that you can be subject to. Now, yes, there are large fines under GDPR and also obviously under the Data Protection Act of 2018, but let's get this into perspective a bit, because the majority of fines under data protection legislation does tend to be in relation to either data breaches or unsolicited marketing. That's not to say that you don't get fines in an employer and employee context, but in relation to subject access requests anyway. It's not to say it doesn't happen, but it is in fact quite rare. Generally, the approach that the ICO will take to any complaints about subject access requests is in encouraging the employer to comply, giving guidance to the employer to comply, and ultimately there could be an enforcement notice, so essentially an order placed upon you as the employer to disclose particular information. But it is unlikely to get that you will get fined in this sort of instance. So I wouldn't worry too much about that. That's not to say that it isn't a possibility, because it is, but it is quite a rare instance in relation to subject access requests. So, employer obligations. What are our employer obligations? Now, these are the broad principles under GDPR and the Data Protection Act. So this isn't specifically looking at subject access requests as such. What we're looking at here is the overall principles of data protection. So we've got the lawfulness, fairness, transparency. So that's the lawfulness of processing. What's your reason for processing? Is that the reason that what's the reason you're collecting the data and using the data? Transparency is all your privacy notices, so that you're informing employees about the data that you are processing and why you're using it. The purpose limitation is making sure that you don't use that information for anything that you don't need to. Data minimization is, as it says, I'll turn to it in a moment because it's one of the more important points, but it's just, don't collect and process data that you don't need to. Make sure your information is accurate, limit the amount of storage that you have, and also the time that you keep the information for. So that sort of crosses over with the data minimization, and of course, integrity and confidentiality. So only those people who really need access to information should be having access to information. If you don't need to see the information, then you shouldn't have access to it. Now, in relation to subject access requests, one of the more important principles, I think, is the data minimization principle. And that is because, quite frankly, if you minimize the amount of information that you keep about your employees, then when it does come to complying with subject access requests, then of course it will be less onerous for you to do so. But as you'll see from the first bullet point on this slide, that actually we have to balance that, don't we? Because whilst we might not want to be keeping documents that we don't really need, we need to balance that with the need for the paper trail. So we need to have a paper trail for the decisions that we make, to be able to justify the decisions that we've made in relation to employees, without necessarily including the general chatter or noise or other bits of information that really don't give us anything at all, or don't justify any decisions that we've been making. So we need to have that paper trail. So obviously, if we're going through a redundancy exercise, or we're going through a disciplinary process, or a 2P process, or whatever process it might be, we will want to ensure that there is a paper trail. We'll want to ensure that if there are discussions happening, then perhaps we want to ensure that there is a record of those discussions. And when I say discussions, those discussions can obviously take place via email, or perhaps even by text message. And it's about retaining that so that we can show that there is a documented paper trail in relation to those issues that were being discussed and those decisions that were being made. And so we need to have that balance. So don't create documents unless you need to, but in some instances, it's in our interest to be creating the documents or creating those emails in any event. And obviously then adhere to guidance on the destruction of documents beyond their retention periods. Now, if you don't already have retention periods set out within your policy documents, then do let me know and we can give you some guidance or recommended retention periods. There are obviously a number of statutory retention periods that you need to adhere to, but in many other respects, with some other many other documents, it's simply a case of good practice and recommended retention periods rather than anything else. But obviously, if you minimize the data that you've got, then the compliance with the subject access request will naturally be somewhat easier. And so, still looking at the broader picture of the data protection environment, when we have a look at the individual's rights, so obviously what we're going to be focusing in a second is the subject access request, the right to access. So it's about getting copies of that information and also being told what the purpose, what data types, and the period of storage of that information itself. The individual has the right to rectification. So often this can follow the subject access request, because then once the information is provided, the employee then might inform you that some of that information is in fact inaccurate or incorrect. And then we've also got the right to erasure, which is not the right to listen to the music of a 80s synth pop band, but rather it's the deletion of information. So it's this right to be forgotten. And I'm sure that, you know, perhaps in some instances you might even have a list of employees that you would like to forget, but I'm afraid you can't do that. This is a right that only the individual can exercise. And it's an interesting issue. I mean, one of the questions, and this is going off a little bit of a tangent, but one of the questions that I've been asked in the last few months was about an individual who had applied for a job and been unsuccessful with the job, and then having been unsuccessful with the job was then writing to the employer asking for all of their information about their job application to be erased, and the employer was concerned that actually that by erasing that data, by forgetting that application, that then if an employment tribunal claim was brought in relation to the fairness of that recruitment process, when I say the fairness, whether there was any discriminatory aspect to that recruitment process, then the employer could be left exposed because it would no longer have the information. Now, I think, and essentially just as a bit of good practice around this, what I would encourage you to do is, as part of the recruitment process, is to actually get consent from the individual as they enter into the application process for you to hold their data for a period of time, say 6 to 12 months after their application has been made, and that then this will help manage that process and therefore give you a justification for continuing to hold that data, and of course protect yourself from what you might perceive to be a risk of a claim. So that sort of concludes the introductory section. So that was the quick revision bit around GDPR and the Data Protection Act. So now getting into the subject access request point in a bit more detail and starting to answer some of those frequently asked questions. Now, so we've got some more principles. Data protection does like principles. So we have got to make sure that when we get a subject access request, that we handle that request lawfully, fairly, and transparently, that we've got to provide the information in a concise, transparent, intelligible, and easily accessible form using clear and plain language, because we also have essentially a template document which sets out other information that we have to provide to them, as well as actually the documents and the data themselves. And it's got to be provided without undue delay, and that's in any event within 1 month, and sometimes can be extended to 2 months. So understanding the scope. So initial assessment, we need to understand the scope and the volume of the request for personal data, okay? Because we need to plan this search for information. And if the information is if we need greater clarification about what is being asked for, and we need to go back to the individual to ask for clarification, then we can pause the time limit that we have got to respond. And I'm going to return to that time limit in a bit more detail in a moment. But we can pause the time limit if clarification is needed. But it's made very clear in the guidance that you can't simply, as a matter of course, just send out a fairly standard letter to those who are making the subject access request, to your employees who are making subject access requests, to say, oh, by the way, we'd like a bit more information in order to just buy time. That's not to say you can't do that, but you can't do that as a routine reaction just simply to buy yourself more time. And then, of course, we've then got the issue of, well, can we refuse the request? And this is something that I'm getting asked more and more, which is when the initial assessment is being done, when the employer begins to understand the scope of the request for data, and they see the size of the request and the amount of data that they're going to have to search for, and the amount of time that it's going to take for the employer to comply, that then they don't want to. And so to what extent can we then use the manifestly unfounded or excessive definitions to actually be able to refuse the request? So I will turn to that as well. So that's that's painting the picture in terms of what we're doing when it first lands. But as I promised you, so turning back to the time limits. So, as I said, when you receive the request, you have then got to deal with that without undue delay, and in any event within 1 month of the receipt. But you can then extend it by a further 2 months where necessary, taking into account the complexity and number of requests. Now, with regards to counting time, I appreciate this is a slightly technical point, but essentially you've got 1 month. So it does mean that depending upon when the request is made, sometimes you might have a few days more or a few days less in order to comply, because clearly if the request is made on for example, the 15th of February, you've got until the 15th of March in order to comply. And so you have got less days in February, so therefore you've got less time within which to comply. That's just the nature of the beast. If you have got a policy that states how many days you are going to respond within, then obviously on that basis, I would recommend that you have a policy that says 28 days, because anything other than that could then result in you tripping up over yourself. Now, what about if we want to extend? So the period where we want to extend it by a further 2 months, can we do that? And this really depends upon whether we can show that the request is complex. And when we're talking about complex, this is the guidance that the Information Commissioner's Office gives us. So it's all about whether there are technical difficulties in retrieving the information. For example, where the information is electronically archived, so it's not easily accessible. So if it's in deleted areas of the system that then cause difficulties to recover it, but it can be recovered, then this would be a reason for extending that time limit. If there is a large volume of particularly sensitive information, so interestingly there it says large volume of particularly sensitive information, it doesn't just simply say a large volume of information. Any specialist work involved in obtaining the information or communicating it in an intelligible form. That doesn't tend to happen in employment situations, because you don't tend to have specialist work involved. It tends to be backbreaking work, and it takes some time to be going through the emails. I completely appreciate that, but that's not necessarily specialist work in my view. Then we've got clarifying potential confidentiality issues around the disclosure of sensitive medical information and the need to obtain specialist legal advice. So it is very clear that that it's quite restrictive in terms of when you can trigger this 2-month time limit. Sorry, this 2-month extension onto the time limit. Having said that, what is the worst that can happen if you are extending the time limit and, for example, an individual then makes a complaint to the ICO that you haven't provided that information within 1 month and instead have provided it within 3 months, having exercised the extension? It's unlikely that the consequences of doing that, unless it has actually caused harm to the individual. So there is the possibility, for example, that if somebody is pursuing a discrimination type claim and that you have inappropriately exercised your 2-month extension in relation to the provision of this information, which has then caused that individual further distress, and that's connected with their discrimination claim, then there could be injury to feelings consequences as a result of that in relation to that claim. But generally, with that exception, the consequences for losing an argument in relation to this complex point and the extension of this 2-month time limit is relatively minor, because it then comes down to the ICO probably simply enforcing that. It's unlikely that you would get fined. I can't promise that you wouldn't get fined, because of course there is the fine regime there. If perhaps you had an exercise, a policy of always exercising this 2-month extension when you had no reason to do so at all, then it's more likely that perhaps the ICO would come down on you somewhat harder. But if you're doing it on a case-by-case basis and you have some justification around these bullet points here, then it's unlikely that you would get into too much difficulty. Now, the other point that I touched on is that, well, when can we refuse to actually comply full stop? When can we actually just say, no, we're not going to? And there are two definitions here. The first one of those is if the request is manifestly unfounded. So again, I'll just make the slide a bit bigger so that you can see all of it, because this one is quite important. So this is where the individual has explicitly stated in the request itself or in other communications that they intend to cause disruption. And so this could be the one that is used in situations where the individual has said right from the outset that they are simply, perhaps, for example, going to bring an employment tribunal claim against you, and they are going to cause as much difficulty for you as possible. Now, that intention to cause disruption may therefore give you the opportunity to then exercise this exemption in relation to compliance with the subject access request. Sort of links in then to the second point, where the requester, i.e. the employee or ex-employee, makes unsubstantiated accusations against the employer or particular employees that are prompted by malice, where the individual is targeting a particular employee against whom they have some personal grudge. And again, you could see that this might play out in situations where it has where the dispute that has prompted this subject access request is founded within grievances or fallings out between individual employees, or particularly between individuals and their line managers. Then again, this might then give you the opportunity to consider that the request is manifestly unfounded and therefore you won't comply. And also if someone is systematically sending you lots of different requests all the time. And so in those instances, you can then also again look at exercising this right to not comply with the request. Just going to move on to the next one before I sort of round up the issue around manifestly unfounded and excessive, because the other one that you can use is where the request is just so broad and so large, and it's going to be such a huge amount of work that you then consider the request to be excessive. And this is probably the most common complaint that I get from employees that are then employers that are faced with these requests. But I put obviously some of the bits in bold here because they're particularly important. So a request may be excessive if it is clearly or obviously unreasonable. Now that is a very high bar that's got to be. That it's not just simply the fact that we consider it a lot of work. It is if it's clearly or obviously unreasonable. Now, then again, we then get back into whether the request is proportionate when balanced with the burden of costs. So then we're having a look at, well, what are your available resources as an employer? So the bar is going to be set differently for different employers in this instance. What are your resources? How many people do you have that can assist in the provision of this information? What are your systems like enabling you to recover this information? So, you know, if you only have 10 employees and suddenly you've got a very large subject access request, then that is going to be less reasonable, or should I say, more clearly or obviously unreasonable for you to comply with it than if you are a larger employer. We've got to have a look at the context of the request and the relationship between the employer and the employee, and whether the refusal to provide the information or even acknowledge that the employer holds it, whether that's then going to cause damage to the employer. So that goes back to the point that I was making a little bit earlier, which is, you know, frequently in these instances, we get subject access requests from individuals who are seeking to bring an employment tribunal claim. And if that employment tribunal claim does include matters such as discrimination or whistleblowing, where there is going to be the potential for them to access compensation for injury to feelings, our refusal to comply with a subject access request could exacerbate that award. And so we do need to have some care. Essentially, tactically, it is often better and more attractive to respond to the request that you believe is reasonable and proportionate. So you put your own boundaries around it. So rather than just simply refusing to provide the information, you take the position that, well, this information, this whole gamut of information that you've requested is excessive. It's too much, it's not proportionate. So what we're going to do is we're going to provide this information. So you provide what you consider is reasonable and proportionate. So there is a level of compliance there. And so then the only argument that is then going to be is whether there should have been greater disclosure or not, rather than going back to the fundamentals of whether in fact you should have been complying with the request itself. It's more likely you're going to get into difficulty for not complying with any request or not providing any information at all than you would be by providing some information, but perhaps just not the entirety of the scope of the request that was made by the employee. So that's when we're having a look at manifestly unfounded and excessive. And I mentioned a little bit earlier when I was talking about the government consultation that that ended in November, that this is one of the areas that the government is looking at, because it is aware that the amount of information, and particularly the amount of unstructured information that gets caught by subject access requests that employers would have to provide, has become so large, and it's become so onerous in some instances, not all instances, but it's become so onerous sometimes to comply with these requests, and it's putting a burden on business, an unnecessary burden on business. And I've got to say particularly that when we're dealing with employment tribunal claims, that of course there is a litigation disclosure process that that has to be gone through then, and often the subject access request is a request that is tactically used to put greater pressure on the employer to perhaps be looking at an earlier settlement of that issue, because of the amount of work that they're having to go to provide this information. So let's have a look at the data. So what data do we collect about people? And well, we've got two categories of data. And again, from all of those GDPR seminars that you've probably been on previously a few years ago, you will know that there are two categories of data. So we've got the personal data, the sort of bog standard data, names, addresses, emails, performance data, contracts of employment, absence data, non-medical absence data. All of that information, all of those emails, those messages, the personnel file of old, any grievances that have been raised, as long as they're not going into this other special category data. Now, the special category data is what we previously called sensitive data. So this now relabeled special category data. So some employers have got biometric data now because we've got the perhaps fingerprint scanning in, or rather than the old-fashioned clock cards or anything. Obviously, health data is special category data. All of your equal opportunities type data, so your racial, ethnic data about individuals, sexual orientation, gender identity information, political and other beliefs information, trade union membership, religious belief, all of that is special category data. So we have to be we have to have greater security around the data. And that doesn't mean, of course, that when a subject access request comes in, that essentially we treat that information differently, because we don't, because there's the employee has the right to all of that information about them, whether it be special category or personal data. So where do we look? Where do we go hunting around for all of this information? Well, as I've been saying, of course, the days of it just being HR pulling out the personnel file and then copying a contract of the employment, any absence record, any information about the training that they've had, promotions, bonuses, merits awards, redundancy, etc. Now, I'm sure you've probably all still got personnel files of some sort or another, whether that be on a bespoke HR system, or whether that just simply be in electronic storage areas, OneDrives and cloud drives and the like of which. We've also got email accounts now. So the email accounts of the people that the individual will work with. Now, normally what we will find is that when the request itself is actually made, we will find that the request is usually identifies the email accounts that the employee wants us to search within. So they will name the individuals, and they will usually then tell us how they would like us to search those inboxes and sent items and what have you. So that will then, you should be using their name, obviously, as a search term. You should be using their nickname, initials, and any other abbreviations that may have been used for the employee in order that you can find those emails. Then you've got the data that is held on other systems. So you've got other local computer hard drives. Now, this, of course, is where, when we go back to trying to drum into our employees about where to store information, and particularly the big thing over the last few years has been, don't store it on your hard drive, put it in the shared area. Obviously, you need to make sure that the shared area is appropriately protecting data. So when I say shared area, it might be that there are various locked off or personal parts of those areas, but at least then you're not then hunting around for information that is not only on the cloud-based system that you have, but you're not then having to go to individual employees' computers to then search their local hard drives, because then that does increase the amount of work associated with these subject access requests. So that comes down to making sure that you've got an appropriate policy in that respect beforehand to reduce the amount of work that you'll then have to do later on. So backed up data, this is the same requirements are placed on backed up data, or deleted emails which aren't actually irretrievably deleted. So we've all got a deleted items box. I'm sure we've probably got many thousands of emails within our deleted items box, and those can still be searched, and those can still be recovered, and they are easily accessible live data. And in fact, even because in reading some of the guidance in preparation, obviously, for this, that having a look at how far that extends and whether it actually extends to draft email. So a draft email that hasn't actually been sent is still personal data about the individual and is potentially disclosable under the subject access request. And then we've got text messages. Now this is then, I mean, if you thought it was difficult before, this is then when it does become even trickier. So text messages. So where we've got work mobile telephones and we've got people communicating via, WhatsApp, MS Teams, just normal standard text messaging, and where the purpose of that is business communication, then there is a distinct likelihood that that is going to be data that is being processed for the business, and that the employees are effectively your agents in relation to that processing, and therefore it's going to be disclosable data from the subject access request. Also, if you've got employees that are holding data on their own personal devices, so I was talking just now about encouraging you to ensure that data is being stored within a sort of central cloud storage provision that you've got, rather than having it all dotted around on these local hard drives, because obviously you've got a data security issue in any event with it being stored on local hard drives if the computer gets lost. But then taking that a step forward, where you permit employees to hold your data or to hold data relating to the business on their own personal devices, then again, they can be acting as an agent for you in relation to the information that's then held on their personal devices. And so that would then be information that they are processing on your behalf and would then be covered by the subject access request. So again, you need to be very clear about your policies in relation to the storage of data, your data, on their own personal devices, because we really do want to try to ensure that we avoid that, because as you see, if we don't, then whilst of course there are data security issues other data security issues in relation to the data protection regime, it causes us a real headache for the subject access requests. A further point as well on this point, well, how wide does this go? Because then we've got the issue of, say for example, many of us now, I'm sure, are caught up on Teams meetings and Zoom meetings and other things such as that, and then perhaps those meetings are getting recorded. Now, again, of course, there is going to be a data processing justification that the employer needs to have a look at in terms of that recording, and for how long that is then kept. How long should that recording be kept? What was the purpose of the meeting? So on and so forth. But if you are then recording these sorts of meetings, then again, that's going to be personal data, which is disclosable as part of the subject access request. So again, the more you create, then the more that there is going to be to provide when you get these subject access requests. And again, it's going back to that principle of data minimization that we were looking at earlier on, into the basic principles of the data protection regime. Why are we creating this information? Do we need to be recording these meetings? Why is it that we're recording them? And looking at the justification around it, because clearly there are consequences of us doing that. So, having then found the information, so we've done all of the searches of the emails, we have dug out text messages, we've gone onto the hard drives of a number of managers, we perhaps even dug out the notebooks. And again, this is then when we need to educate our managers in relation to the amount of information that they are creating, because if, for example, I was just trying to find a notebook, but pretend I've got a notebook. So if you have a notebook that you are then writing notes in as a part of a diary entry as to what you're doing that day and the conversations that you've had with employees, of course, what that does is it can be quite helpful, again, from that paper trail point of view, because often we want a good paper trail to show that we've done X, Y, and Z. We want evidence when we're challenged about, if for example, we have gotten an employee who is underperforming, and the manager has made a note in their diary about the fact that they've had an informal conversation with them about their underwhelming performance, then we've got evidence of the fact that that conversation took place. We're not just simply relying upon the manager saying, well, it did take place, and the employee disputing that, because we've got contemporary evidence to that end. But the problem then that we create when we've got managers who are making notes within notebooks or within diaries is that again is personal data. That again is disclosable as part of a subject access request. And we need to know whether the manager is doing this or not. We don't always know. Some managers do it, some managers don't do it. And so again, it would be prudent for you to have a policy position on this. It could simply be that yes, you can keep your diary, but at the end of the day, upload the picture of the diary page onto our cloud-based system, and then we can easily recover it. I say easily, at least we can recover it from there. And of course, there's a data security issue there as well. So we're protecting that data by doing so. And so you can see why you've got to, when we've got to plan these subject access requests, and we've got to sort of explore where the data is. But once we have the data, having found it, what do we then provide? Well, our obligation is to provide personal data. So it's not to provide personal data about others, but naturally, of course, what often happens is that an email that then has got not just reference to the person that's making the request, because they are identified in, for example, an email, it doesn't necessarily follow that is personal data. The information has got to relate to them. And so that, as I said, that's more than just simply identifying them. So there isn't a huge amount of guidance about what the whole relate to them means, but essentially they've got to be the subject of part of the email. It's got to be about them rather than simply identifying them. But of course, what that means is that then we produce, or we output all of these emails that we've located as part of our search, and we've then got to go through them. We've got to essentially consider each document and decide whether it includes information about them or whether it simply identifies them. And if it contains information about them that relates to them, then it is going to be disclosable. If it simply identifies them, then it's not going to be disclosable. And even where, for example, the information is pseudonymized, so that means it might not have their name, but they are identifiable from it, it's still, again, disclosable. It's only if it's truly anonymous would that data then not be disclosable under the subject access request. We've then got the issue, as you can see on this slide. So it's likely, often within emails, because there tends to be general chatter about other things, is that then there is going to be reference to other people within them. So this is where we've got the issue of third-party rights, or the rights of other employees. So it's where the information refers to others. And so what we've then got to do is we've then got to try to reconcile the privacy and the confidentiality of the other individual when we are then obviously making the disclosure of the information that the requester is entitled to. So even once we've located all of this information, it still can be somewhat complex. Now, what the Data Protection Act says on this point is that you don't have to comply with the subject access request, or this particular part of the subject access request. Say you've got an email and it identifies another individual, then you don't have to provide that document, that email, unless the other individual has consented. So you simply ask them, is it okay? Or alternatively, it is reasonable for you to comply with the request without that individual's consent. And so you're not obliged to ask for consent. I mean, sometimes, for example, it might be relating to a third party, an ex-employee who you don't have contact details for anymore. We might be in a situation where it's inappropriate for the other individual to know that the subject access request has been made. So then that turns to well, is it going to be reasonable to disclose without consent? That tends to be where we go with this quite frequently, because otherwise we're asking for consent from sometimes many people indeed. And so what we then need to do is, again, we have to have a look at the context. We have to have a look at, well, what is the type of information that we would be disclosing here about the other person? What is our duty of confidentiality? So what is the information? And so, for example, it's likely to be reasonable to disclose information where the other person, the other individual's role includes line management responsibility for that employee, and that the making of the subject access request, for example, refers to the performance management of them by their manager, and therefore it's just going to be simply reasonable for you to provide that information. It's going to be reasonable for you to comply with that request without asking for the consent of the manager. But if we were in a situation, so we have to weigh that against the issue of confidentiality. So if we have got a request that is made by an employee who is alleged to have conducted an act of sexual harassment, for example, and they put in a subject access request in order to identify the person that has made the complaint about them, then clearly the issues of confidentiality and the potential consequences, the potential damage that you might do to that third party is so significant that that then will enable you to, certainly without that individual's consent, to refuse to comply with that request. But as you can see here, context here is absolutely fundamental. But what we will be doing when we get emails and where it does refer to other individuals, one of the simplest solutions is to redact information. Now, not necessarily like this. Obviously, this is a slightly extreme version of a redaction, but we will redact emails, and so therefore where we've got an email that refers to other individuals, that rather than having to rely on whether it's reasonable to comply with the request without seeking the consent of that third party, or seeking the consent of that third party, we simply take the data out because it's irrelevant. Now, that's not going to work all the time, because sometimes the data might still be relevant. It might still be the personal data of the individual, even though it refers to somebody else. So then we're still going to have to go back around the loop in relation to consent, or whether it's reasonable to continue to provide that information without consent. But one of the most common ways around the problem is to redact information. So strongly encourage you that if you are ever in a situation where you are having to manage manage a subject access request, ensure that you have one of the better versions of Adobe Acrobat, because it does have a redacting tool on there that then enables you to absolutely eliminate the information behind it. Do make sure that you don't make the mistake that was made in some quite serious litigation in America just a couple of years ago, and it was all to do with Donald Trump and part of his cabal of people, where the lawyers in that instance thought they'd redacted it, but in fact all they'd done is they'd just put black marking over the text, so all the recipient had to do was then change the color of the text that sat behind it to white, and they could read everything. So you do have to make sure that you redact it properly, because if you don't, then it's still possible to recover that information. And then, of course, we could then be in issues in relation to the duty of confidentiality that we do have to the third party. If you can imagine that happens in a situation, in a sexual harassment type a case where then information is inappropriately disclosed, then it can cause an awful lot of difficulty. And so just to run through a sort of worked example for us here. So, and I'm basing this around an emails worked example simply because that tends to be nowadays where the vast majority of information is. So what we want to do is we want to first of all collect all of the relevant emails, and then we've got to go through them. We've got to have a look at them to see then whether they contain personal data. So it's that relevant data, not just the fact that the individual is identified, but it's about the fact that that the information relates to them. It's about them. We then take those emails that contain that personal data and have a look at them to see whether there is also personal data relating to other individuals. And if there is, then we've got to assess our duty of confidentiality to that individual. What is the context of this information? Has the other person consented? Or is it simply irrelevant and therefore we just redact it in any event? But it is as you can see, a time-consuming process. It is one that you need, that sometimes you will need help with. And so you either need to find somebody who is adept at doing this sort of work for you in-house, or of course get somebody else to help it with you. There isn't nothing necessarily wrong with outsourcing this sort of work. You can do that, and particularly what I find is that the first port of call tends to be to the IT department to get them to undertake the searches and to output all the emails. And then you essentially just need someone to trawl through all of that information to make the decisions in relation to whether it contains personal data, whether there's anything in there that is confidential, either in relation to the business or in relation to other individuals, and then begin redacting or seeking consent, or just providing in any case. So that's the sort of route that you have to go through. Now I'm conscious, if you just bear with me, I'm conscious that there have been a number of questions that have just sort of popped in that I haven't been addressing, but I promise you that what I will do is I will make sure that, because it's going to take me a little bit of time just to have a quick read of them. There's quite a few questions, and I'm not surprised because it is a rather tricky and difficult area. But as I said right at the beginning, I'm not forgetting them. I'm not ignoring them. What I will do is I will take them and I will respond to them when I send the slide deck out. So hopefully that will be, might be later on today, but certainly by the end of tomorrow. And then when we then turn to a little bit of a checklist. So you need to check the subject access request is valid. And by the way, I'm calling it SAR. You can call it DSAR if you want. Both terms are both bits of terminology are perfectly valid and perfectly fine. So you need to check that it's a valid request. You need to timetable your response date. You need to acknowledge the request. You need to decide who is responsible for managing the disclosure, ensuring that proper instructions are given to the appropriate staff to search, getting your authorization from IT. If it's not IT that are doing it, then you will, in all likelihood, need to be given access to these inboxes, to these email accounts, so that you can undertake searches. You need to decide on the redactions. You need to decide whether you're going to seek consent. You're going to need to decide whether you're going to disclose without consent. You're going to need to decide who is going to search for information, because, like I said, there is sometimes going to be information that exists that you simply don't know of because they're in notebooks or similar other sources. And then you then provide this information to the employee within the timescale. So that's within either the 1 month or the extended 3-month period. If you've exercised that right, because the request is complex, you then provide that information to the employee. And there's a sort of standard template letter that you need to provide, because there's also other information that you need to provide in the covering letter. It's not just simply a case of sending the pack of information to them. And so I hope that you found that useful. Amusingly got my any question side, and I know that there are questions, obviously, as I've just referenced that, but I'm very conscious that that obviously we're now 28 minutes past 1. We're sort of hitting the boundary of the hour, and so I don't want to overrun. But as I said, I promise that I will answer all of your questions that you've popped in as well. And obviously, if ever you want to get in touch, I mean, you've no doubt got my either my LinkedIn details or my details from any emails that we might have sent to you previously. But here are my contact details. Please do LinkedIn with me if you haven't done so already. I do put a fair amount of content on LinkedIn. I've also got a LinkedIn newsletter as well. As you can see, we've got podcasts as well, which aren't necessarily undertaken quite as regularly as all of the LinkedIn updates, but they are there. And of course, if you want to talk to us about helping you with any subject access request, or in fact any employment law or HR matter, then please do feel free to get in touch. We've got lots of options for employers in terms of fixed price annual arrangements, sort of all you can eat arrangements, or we can just do simple, straightforward fixed price pieces of work, or in fact just on a very ad hoc basis, really entirely up to you. So if you do want to get in touch, then please do. But I hope that you've found that useful.